Today, the session we have will be about the labor law and employment aspects of the transposition laws of the EU directive in the EU. We have a great panel, but before introducing the panel, I would like again to point out that we brought together in this working session the best, and this is really my view, the best employment lawyers from leading independent firms with a strong international focus and practice. Italy with Pavia Ansaldo, Spain with Bartolome and Briones, Germany with Atsumi Sakai Jensen, the Netherlands and Belgium with AKD, Luxembourg with Molitor et Associés, Ireland with William Fry. Magnuson will represent Finland, Sweden, Denmark, Lithuania, Latvia, and Estonia, and France. As you can see, we cover a significant part of the EU. Now, let me introduce to you our distinguished panelists. Ladies first, as we are used to say. So, we go directly to the introduction, and thank you very much with the pictures. Valentina Simonelli is a partner at Pavia Ansaldo since 2010. She is working in the Milan office, and she is specialized in labor and employment. We also have the chance to have with us Paola De Pascalis. Paola is an of-counsel with Pavia Ansaldo, and she works with Valentina and the other members. We have also the pleasure to have with us Magdalena Berg. Magdalena is an employment lawyer with Magnuson in the Stockholm office. Welcome, Magdalena. We also have our Irish friends, Catherine O'Flynn. Catherine is the head of Williams Fry Employment and Benefits Department. And Nuala Clayton is also with us today. Hi, Nuala. And Nuala is also a partner in this department. William Fry is one of the leading law firms in Ireland. And now, hopefully I didn't miss any ladies. Now we go to the gents. My friend, Michel Sapin. Michel is a senior counsel at Franklin, but he is, and it was, I would say, a former Minister of Justice with François Mitterrand, a former Labor and Minister of Finance with François Hollande, and interestingly enough, Michel gave his name to the French whistleblower legislation. So Michel, thank you for joining us. Juan Carlos Lombardia. Juan Carlos is a partner with Bartolome and Briones and is heading the employment group. So welcome, Juan Carlos. We also have Pascal Van Schaik. Pascal is an employment law partner with AKD, which is a firm with offices in Benelux. Pascal, welcome again, because you were in group one yesterday. It's always a pleasure to have a representative of Molitor et Associés, and this time this is Régis, who is with us, Régis Muller, who is a highly experienced employment lawyer with this distinguished Luxembourg firm. Last but not least, we also have the pleasure to have Marcus Gortan, who is an associate in the Labor and Employment Group with Atsumi Sakai Jensen, a Japanese-based law firm with offices in Germany. Marcus, welcome as well. And very shortly, I am Patrick Thiebard. I am an employment law partner at Franklin. So, I think that we should start right now with our very first question. So thank you. Oh yeah, we go. Now there is one, sorry. Yes, there is one. State of implementation of the EU directive on whistleblowers. as you can see at this point in time, and my panelists will probably correct me if I have made a mistake in this slide, but only 2 countries so far have transposed the EU directive into the national legislation. Sweden, which was the very first, so congratulations, Magdalena, and France in March 21, 2022. The other countries, bill is in progress, but I know that in some countries it's a little bit late. Panelists, do you have any comments on this? Do you think that, because everybody is late now, because I think, if I don't make a mistake, that we were supposed to have this transposition, if I don't make a mistake, this 17th of December, 2021. So any comments from you guys on, do you think that you will have your legislation very, very soon? For instance, Valentina, I had the impression, hopefully wrongly, that Italy was really late. Do you confirm this, or it's just an impression?
Yes, I do, because the parliament just gave a delegation to the government to draft the law within the framework given by the directive. And here we are. I mean, there is nothing more than delegation.
Thank you. Thank you. Grazie, Valentina. I don't know if any of you wants to comment this, otherwise we can go directly to our very first question. We'll have 4 questions today. And of course, ladies and gentlemen, feel free to ask questions. You have the Q&R button, so please use it, and we'll be very happy to answer any questions you may have. So I'd like now to change the slide and go to the very first question. Thank you. What was the political, historical, cultural, and economic context before the implementation of the directive? For this very first question, I would like Michel Sapin to tell us a little bit more, because Michel, actually, you have a name, a law with your name. So you are the best for France to speak about that. Please, Michel, tell us. And Michel, you're on mute.
Excuse me.
Okay, good, thanks.
Okay. So thank you, Patrick, and hello, everyone. I'm very delighted to participate in this exchanges and to be able to share with you my experience as St. Patrick and my assessments on the French context before the implementation of a new European directive on whistleblower. The general status protecting whistleblowers in France dates from the end of 2016. It was developed by the government and parliament as part of the implementation of a new legislation to effectively combat corruption in France and abroad. This text now bears my name without it being the fruit of my will, but no longer a consequence of a phenomenon of modern communication. I did not protest, considering that it was better to give its name to an anti-corruption law than to a corruption scandal. Among the ways to effectively fight corruption are, of course, the use of whistleblowers in the health area and the establishment of effective whistleblowing system in companies. But rather than continue to create a special status for whistleblowers in corruption, the French preferred to create a global status covering all areas. Until then, we had in France different status covering specific areas, health crimes, tax fraud laundering, and 1 or 2 other areas. Since December 2016, we have had a global status covering, including international commitments. What were the main issues debated at the time? They will not surprise you, because you found them during the drafting and adoption of a directive, and we find them in the national debates of the occasion of the transcription of a directive in each national legislation. One, the disinterested nature of the whistleblower and his good faith. Two, the protection of the whistleblower alone or also of those who accompanied him. And three, above all, fundamental question that will be addressed during this webinar, alert channels, internal, external, public or not. On this point, the French had chosen to favor the internal channel before allowing expression outside the company or legal entity concerned. I will conclude by stressing the very close proximity between the directive and the legislation existing in France. The transposition of the directive will have required only small adjustments, mainly on the issue of alert channels. Some consider that French legislation in the field of whistleblower served as a basis for the drafting of a directive, but to say that would be to flatter the famous French arrogance. I will therefore refrain from it, especially since giving its name to a law at the origin of a provision is already arrogant enough. Thank you for your attention.
Thanks, Michel. Thank you very much. Now, I would like to ask a question to Marcus and Régis. Marcus is representing Germany. Régis is representing Luxembourg. Marcus, Régis, I understand that in your jurisdictions, you didn't have any national legislation on whistleblowers. How do you explain that? Marcus, would you like to start answering to this question?
Yeah, thank you. I would like to start maybe just to look at the current situation, why Germany is so late. You can say Germany was sleeping, and after the EU Commission initiated an infringement proceeding, Germany woke up and now provided a draft in a very early stage. That draft isn't good. It's very criticized. Why didn't Germany have a whistleblowing code before? We had many attempts for whistleblowing code, but it always failed due to internal political conflicts between the Social Democrats and the Christian Democrats, leading to the situation that we never had some sort of code or anything like that. Nevertheless, the highest court of labor law already decided a couple of years ago that whistleblowers cannot be get terminated, or their employment contract cannot get terminated if they are blowing the whistle. So, and I guess that took Germany as enough for protection of whistleblowers. Yeah, and also maybe at a look at the historical side, Germany had skepticism caused by the Nazi regime and GDR. I think that caused Germany never to saw or never wanted to initiate a whistleblowing code. And also in Germany, we have strong labor unions, which are always a point of contact for grievances within the company. Yeah, it's from the side of Germany.
Thank you, Marcus. Régis, what is your view on this? Régis, are you with us?
I'm sorry, Patrick. I stay on mute. Thank you, Patrick. And regarding Luxembourg, the directive is currently in process of transposition, and we have no national law which deal and which regulates whistleblowing from a global standpoint. However, we have various laws in specific sector which are regulating whistleblowing and dealing with whistleblowing. For example, a law of February 2011 regarding the fight against corruption, a law of July 2015 amending and implementing whistleblowing in the financial sector. We have also a law of 2016 on market abuses, and other various sectors, such as, of course, discrimination, health and safety at work, and also moral harassment. I think, like Marcus says, for Germany, we have no tradition of whistleblowing in Luxembourg. And like in a lot of European countries, denunciation has a very negative image since World War II, notably, and also as the employee has a family vision of their employer. So on the one hand, the government and the economic players are very favorable to a global protection of whistleblower and support a quick implementation of the directive. And we will discuss this afterward, but they also enlarge the material scope of the directive at the moment. But on the other hand, all players also pointed out the pitfalls of such a global regulation, which is, for example, the development of a culture of denunciation and suspicion, but also the potential abuse by employee of such a protection.
Thank you, Régis. Merci, Régis. And now let's go to south of Europe. Juan Carlos, for Spain. I understand that in Spain there is no uniform regulation, I would say, yet. But you do have sectorial rules. Should I understand that the Spanish authorities are somewhat distrustful of whistleblowers? How do you explain that, Juan Carlos?
Thank you, Patrick. Really, first of all, related with the transposition of the directive, we are really late as the other part of the European countries. We have a preliminary draft of law that was approved on March. And as you say, really, we had some sectorial rules that promotes the whistleblowing channels and also the protection for the whistleblowers, but we do not have an integral regulation, and really the directive comes to complete this type of regulation, sectorial regulation, that promotes individuals to communicate to the authorities potential infringement of on the law. But really, what we are really is that we have these sectorial rules that starts with the modification of the criminal code in 2010 and with the implementation of the corporate compliance program. That was really a very important point and a starting point for whistleblowing channel here in Spain.
Okay, thank you very much, Juan Carlos. Valentina and Paula, what are your views regarding Italy, please?
Paula?
Sorry. Okay, for Italy, the situation of whistleblowing regulation is absolutely particular, because in the private sector and with the partial exception of certain fields such as banking, insurance, financial sector, antitrust, and health and safety, the provision on whistleblowing are part of the legislative decree 231 regulating the criminal liability of companies and legal entities, and therefore are applicable within the limits of its scope. Then the whistleblowing procedure and protections are a part of the compliance model of organization required by the decree 231, which are aimed at providing specific rules within a company in order to avoid the entity's criminal liability in case a crime occurs. However, at the present, the adoption of these models is not mandatory, and so the whistleblowing regulation is not mandatory for the companies, as their implementation is a free decision of the company as well. Maybe Valentina could
Yes, I would like
further.
Yes, I would like just to point out that from another point of view, it is true that companies are not obliged to adopt the compliance organization model. However, for a company of the private sector, in order to work with or to supply services or goods to the public sector, it is necessary to have adopted the compliance organizational models and therefore also whistleblowing procedures. In other words, even though not legally obliged to adopt whistleblowing procedures, companies of the private sector need, in any case, de facto, to obtain and to structure whistleblowing policies.
Thank you very much, Valentina and Paola, for this interesting view regarding Italy. Now, let's go to Sweden, the Netherlands, and Ireland. You know, it's like the Eurovision contest. You know, we go from one country to the other. So, actually, Sweden, the Netherlands, and Ireland have in common with France to have put in place a comprehensive whistleblower protection. Michel explained the French context. Let's start with Pascal. Pascal, what was the Dutch context for the implementation, well, for the putting in place this comprehensive Dutch whistleblower legislation?
In 2016, the so-called House for Whistleblowers Act was established in the Netherlands. And this act was established because we had a lot of cases of whistleblowers that got media attention. And in most cases, it were very sad stories because the whistleblowers in the end often lost their jobs, lost their income. So the legal debate was really trying to create comfort for the whistleblowers, get protection. The House for Whistleblowers was implemented in 2016, and against this context, the directive will be implemented. But what we saw with the Dutch House for Whistleblowers Act is that though in theory it is a good act, and in theory it can create a lot of protection for the whistleblowers, in practice it did not work out as such. I will give you one example. Definitions are not always clear. Whistleblowers can only report about matters that relate to the public interest, and it's not always clear what the public interest is. If you work at the government and you see the embezzlement of money, it's clear that the public interest is involved. But if you work at a medium-sized law firm and you notice that one of your colleagues are embezzling money, you could argue whether or not the public interest is involved. And this lack of clarity has a certain chilling effect on potential whistleblowers. And that's why, well, there is a lot of criticism about this act, though it did make some difference in specific cases. We still think that it has a chilling effect on whistleblowers because of the lack of clarity. And now we have the EU directive, but we also see there that there is not always full clarity still. So, well, we will see what future brings here.
Thanks, Pascal. Thanks. Magdalena, can you tell us a little bit more about the Swedish context, please?
Yes, of course. Well, Sweden had whistleblower rules in place. The so-called Whistleblowers Act was introduced in 2017, and we did so because it was a need to encourage whistleblowing. And the Act provided that employees and temporary agency workers had whistleblower protection. The Act was also mandatory, and it provided protection to workers in the public and the private sector. But the scope of this law was criticized as it only applied to serious misconduct in the workplaces that could lead to imprisonment. And as you may imagine, the connection between misconduct and imprisonment was not very clear, and it was not easy for the whistleblower to make that assessment if the misconduct was so serious that it could lead to imprisonment or not. Employers were not required to implement procedures for internal reporting according to the previous act, but some employers did, just because they wanted to encourage internal reporting and they wanted to avoid a situation of public disclosure. In fact, there have only been a few cases in the courts regarding the previous act, but still my personal view is that the act had a purpose in that it clarified that whistleblowing was okay under certain circumstances. And I would also like to repeat the view of my German colleague that we do not have a particular strong history of whistleblowing in Sweden. The unions are strong, and also the employment protection is very, very strong. So, of course, whistleblowers have and has this protection against terminations and dismissal. They are also protected by those rules.
Thank you, Magdalena. Yes, I think your point is relevant. Many countries do not have a real culture regarding whistleblowing, and you're right. Unions are not necessarily very happy because they take the view that you are taking their prerogatives, which is also true. Now, Ireland, I think it's Nuala, but Catherine, if you want to speak, tell us about the Irish context, please.
I will. Yes, thank you, Patrick. Yes, this is like the Eurovision. So our 12 points go to. So in Ireland, as you said at the top of the call, Patrick, we have a bill in progress, but we are late. But it's quite well progressed, well developed. It's still going through the legislature. Our Attorney General is still grappling with issues like retrospective effect and things like that. But I would say we might have it towards the end of this year. The delay probably not unrelated to the raft of legislation we're getting through at the moment in relation to remote working and flexible working, like all of the other countries. And this 22 Act will transpose the directive by amending our current Act, which has been in force since 2014, actually. And I think it's fair to say that that Act was considered quite innovative at its time. And at the time, Ireland was about the 6th country in the EU to introduce comprehensive legislation for the protection of whistleblowers. And it's still, our regime is still regarded well internationally, but certainly the new legislation will see considerable change. And Nuala will discuss that shortly. But as regards the kind of historical background, similarly to the other speakers, there certainly were negative connotations when it came to whistleblowers. Similar to what Pascal said, there has been media reports of whistleblowers in the past who had a terrible time in terms of their reputation and their job and their families. And I guess the 2014 Act was designed to remedy that. And it certainly did to a certain extent and provide a lot of protection to whistleblowers. But of course, there's always criticism. So some criticism leveled at that act would be the fact that there was a cap on the compensation that could be awarded, unlike some other jurisdictions where it was uncapped. So it did kind of lead to a question as to whether there was a true incentive there to blow the whistle. But all of that said, in the years since the enactment, there have been hundreds of disclosures made in Ireland, and at least 50 cases have been adjudicated upon under the legislation, which shows that despite the kind of perceived risks and the challenges, workers certainly do report wrongdoings in Ireland and seek to avail of the redress mechanism under our Act and are often successful. So that's the Irish perspective, Patrick.
Merci. Thank you, Catherine. Thank you. So now we change the slide because we go to second question, which is, does the EU directive create a whole new legal framework in your jurisdiction, or is it merely an update of the existing comprehensive whistleblowing legal system in force in your jurisdiction? Let me give you very quickly the French point of view. Unsurprisingly, I would say the provisions of the EU directive have been used as a reference point by the French legislator to adopt a new whistleblower legislation. Because at the end of the day, if you look at the EU directive relates to violation of EU law. I don't know a single country who would have been very pleased to have two legislations, one regarding violations of the EU law and a second one about violations of the national legislation. So because of that, again, the national legislators, France, but not only, decided to set up only one law. And obviously, for the countries, and you saw the countries, Ireland, Sweden, the Netherlands, France, who had already a legislation, of course, we had to review it. Michel said very clearly that we made significant change to the reporting channel. We'll go back on this. The definition of the whistleblower is larger. I understand that this is the same in Sweden, for instance. Magdalena will tell us. So, Regis and Juan Carlos, well, since you do not have yet any uniform regulation, how do you believe that your national legislator will I would say will react regarding this obligation to transpose the EU directive? Can we start with maybe you, Juan Carlos, first?
Yes, for sure, Patrick. Related with or in our experience and in practical terms, we consider that all the sectorial regulations are going to remain in force because there are some particularities that are not reflected in the directive, and then these provisions will remain as they are not contrary to the directive. But really, some of the sectorial regulations should be modified and adapted to some of the formalities that the directive is considering related with the procedure, and also related with some of the legal requirements related with the confidentiality of the procedure, because sometimes we have some sectorial regulations that does not comply with this confidentiality in the investigation procedure, and taking in consideration the potential fines that perhaps companies are facing in case that the investigation procedure is not complying with this legal frame that the directive is building, really we are going to have an economic consequences for the company. Then for sure the sectorial regulation is going to be adapted, but remaining for some of the particularities. Yeah.
Thank you very much, Juan Carlos. Regis, the floor is yours for Luxembourg.
In Luxembourg, the question is dealt with by the current version of the Bill of Law, which is aiming at transposing the directive. And according to this version and to the Bill of Law, the sectorial law will not disappear nor be incorporated in the future legislation. It will also not be updated. The application of the sectorial law will be assessed on a case-by-case basis, depending on the level of protection that they offer. So Article 1 of the Bill of Law at the moment says that where the condition of application of a sectorial law are met, the sectorial law will apply, provided, however, that the protection is not less favorable to the whistleblower. So, in other words, and as far as Luxembourg is concerned, sectorial law will continue to apply, but the author of the report will be entitled to the level of protection, at least the level of protection of the future legislation, further to the transposition of the directive. Thank you.
Interesting, Regis. Thank you. Valentina and Paola, can you tell us your view for Italy, please?
Okay, well, as said before, in Italy we have different whistleblowing systems depending on the sector where we can that we can consider. Each system is more or less based on the same main principle, but otherwise there are some difference each other. That means that even though it's not possible to anticipate with certainty how the directive will be implemented in Italy by the future legislation on this hypothesis to get a unique and uniform legal framework. Also, because we can say if the implementation of the directive will result necessarily in the repeal of the existing sectorial provision, or such provision will be adapted or modified in the implementation process. What we can guess is that considering the purpose of the directive and its contents, we can imagine that the directive encourages the adoption of a general and uniform framework for all sectors, or at least a perfect coordination between the several provisions of that different system of whistleblowing.
Okay, thank you very much, Paola, for the Italian perspective. Now I go to the countries which already had legislation on whistleblowers, so Sweden, the Netherlands, and Ireland. So my question to the three of you, Magdalena, Nuala, Pascal, is what consequences do you expect the implementation of the e-directive will have on your national legislation? Pascal, would you like to start?
Yes, of course. Well, I think it's a mere update. Yes, the scope of persons involved will be expanded a bit. Yes, the scope of the breach that falls within the scope of the law will be expanded with the breach of EU law. But I would argue that to a large extent overlaps with the current definitions. There is one particular change that I would like to highlight, which is a difference compared to how we do it now in the Netherlands. Until now, the Dutch Supreme Court says that there is a duty of loyalty of employees towards his or her employer, which means that if there is a report, the whistleblower should first report internally. And only then, if that does not help, the whistleblower should go to an external authority. And this is something that the directive will change. Yes, it's still promoted to report internally, but there is also a possibility to immediately report externally at an authority. And this will make a big difference in mindset in the Netherlands.
Yeah, thank you very much. Magdalena, about Sweden, please.
Yes. Thank you. Sweden has adopted the same approach as France. We have created a completely new legal framework which covers the directive, the standard of the directive, but it also covers issues in a work-related context that are of public interest. And this is something whistleblowers can report on. And this has been criticized as very difficult to understand, really, what is an issue of public interest or not. And obviously, there is a risk that there won't be so many whistleblowers just because the fact that the act is very comprehensive, it's very complex, and it's difficult to understand.
Okay, thank you. And we will close this question with Ireland. I think, Nuala, you may provide us with the Irish perspective.
Yeah, thanks, Patrick. I suppose, as you mentioned, we have existing legislation. It's the 2014 Act. And in order to transpose the directive into Irish law, we have in place a comprehensive draft bill since February of this year. And that bill actually contains over 30 amendments to our existing legislation, which are going to be required in order to transpose the directive effectively in Ireland. So, for example, as others have mentioned, there's a broadening of certain definitions under the legislation, such as the definition of penalisation. There's also a broadening of the applicability and scope of the legislation to include certain individuals that were not previously included under the Irish law, such as shareholders, volunteers, job applicants. And importantly, in Ireland, we did not have a requirement for private sector employees to put in place whistleblowing reporting channels. And when the directive is transposed, that will be amended in our national legislation to provide for that requirement. So in my view, I suppose, rather than a simplification of our framework, we had already, as Catherine mentioned, a well-regarded act, which was very comprehensive and is viewed as very comprehensive already. This is going to increase the protections offered by that act and arguably make it slightly more complex for Irish employers. And I think one noteworthy aspect of that is a change to our national legislation. In the draft bill as proposed, for the first time, we are going to include, if the bill passes in its current form, criminal offences and criminal penalties under the Irish law. So some of those are very significant for employers in Ireland. They can attract fines of up to €250,000 and the potential for up to 2 years imprisonment. And that specifically relates to a failure to meet the requirements in relation to reporting channels. So in terms of our updates, that's a very significant change in the Irish legislation. And arguably, there are varied consequences for our national law, but certainly things that employers in Ireland need to be very alive to as this progresses.
Okay, thank you, Nuala. Thank you for this interesting development. Now we changed our slide because we'll go a little bit further into the detail. So Maxime, if you can, thanks. So question is, how is or how will your national law impacted or be impacted? And during the next 15 minutes, I would like to divide the answer to this question into two groups. Sweden and France, because as you understand, these are the two countries which have at this point in time, at least, already transposed the EU directive, and of course, the other countries which are in the process of doing so. So Magdalena, for let's say 7 minutes, let's discuss together on several issues. The first one I would like to discuss with you is the definition of whistleblower. Do you believe that your new Swedish legislation has enlarged the definition of whistleblower or not? Please, Magdalena.
Yes, I would say so. The whistleblower definition is much broader now in our new act. The definition of a whistleblower is a person that in a work-related situation has received or obtained information about misconduct and actually reports on it. And the scope of persons who can blow a whistle is in addition to employees and temporary agency workers, for example, persons who seek employment, interns, volunteers, business partners, and even subcontractors, self-employed persons, board members, managing directors, shareholders who are active in the company. And the protection also applies to persons who have belonged to these categories of people and have obtained information during the business relationship. So the definition of a whistleblower is very broad, I would say, and is based on the directive. And also, in addition to the whistleblower himself or herself, also other persons are considered. Those are the persons who assist the whistleblower, and that could be a safety representative working in the workplace or a union representative working in the workplace. They are protected too. And also persons that are having a relationship with the whistleblower and that could suffer from retaliation.
That's interesting. That's interesting because France is not really a different. We also have a broader definition of whistleblowers. Just to give you two examples. In the Sapin 2 legislation, you have the obligation, if you wanted to qualify whistleblower, you have the obligation to show a complete disinterest. You had to be unselfish, if you prefer. Nowadays, in the new legislation, this requirement of unselfishness has been replaced by a new condition, which is the absence of direct financial consideration. What does it mean, practically speaking? It means that if you denounce a sexual or a moral harassment, you can be a whistleblower nowadays. You could not be a whistleblower in the previous legislation. Another example, you were under the obligation to have a personal and direct knowledge of the facts if you wanted to qualify whistleblower in the previous legislation. This is over. Last but not least, we have new people in the whistleblower scheme, job applicants, business partners, subcontractors, facilitators, for instance, non-profit associations helping whistleblowers to make their report, this kind of things. So that's the first point. Second point, Magdalena, I would like to discuss with you. We still have 4 minutes for this discussion between the two of us. Internal reporting channel versus external reporting channel. How does it work in the new Swedish legislation, Magdalena?
Yes, this is a change because now the whistleblower can choose whether it's internal reporting or external reporting. And it's also possible, of course, to do both at the same time. So there are no limitations under the Swedish Act in this regard.
Yeah, and surprisingly, this is absolutely the same in France because this is a requirement from the EU directive. So sorry, Michel, because I know that Michel is very keen that people go first to the internal reporting channel before going to the external reporting channel. We'll discuss on this during session number 6. So please stay with us until the very end of this webinar. But this is exactly the same. It also means, at least for France, that what I would call the public disclosure to the media, disclosure to the social media as well, is subsidiary. However, even if it's subsidiary, the cases allowing direct disclosure to the public have been extended in case of serious and imminent danger, or when referring the matter to a competent authority would put the reporting party at risk of retaliation. It's a little bit subjective. Just to tell you one thing, we don't have the decree yet, the implementation decree of this new legislation. Last but not least, dear Magdalena, tell us about the protection granted to whistleblowers. Do you believe that the new Swedish law has significantly strengthened the protection to the whistleblowers, or not that much?
Not that much, I would say, but it still has been clarified that retaliation and attempts of retaliation is forbidden. And it is also forbidden to prevent or try to prevent reporting in the workplace. And that could be, for example, if a whistleblower turns to his or her boss with a report and the boss doesn't inform about internal reporting channels in the company, that could be considered as a case to try to prevent reporting and could fall under the law. And also, it has been clarified that the whistleblower shall not be held liable for having breached the duty of confidentiality when making a report, provided that the whistleblower had reasonable grounds to presume that the reporting of the information was necessary in order to reveal the misconduct. So that is a clarification, I would say.
And this is exactly the French point of view. We have what we call the creation of immunity from civil liability, so it's not different from Sweden. We have also as I said, a protection to people and organizations assisting whistleblowers. So they have also this immunity, including from criminal liability, unless obviously they would breach some confidential area, secrecy of judicial deliberations, national defense secrecy, medical secrecy, and lawyers' professional secrecy. So that is the point. And in France, we have now significant criminal, I would say, punishment, 1 year's imprisonment, a fine of 15k euros for individual and 75k euros for companies who would be in breach of the whistleblowing legislation. So this is for the two countries having already a legislation. Now, for the other 7 or 8 minutes, ladies, gentlemen, I would be interested to hear from you. So I don't know, it's up to you to say something. Juan Carlos, would you like maybe to provide us with the Spanish point of view?
Yeah, for sure. I think that really here in Spain, we will follow the same steps that France and Sweden related with the regulation, because the preliminary draft of the law is extending the concept of whistleblower, is also reinforcing fines for not complying with the whistleblower channel. We are talking about potential fines of 1 million euros in case of legal entities. This is very serious, and this is a proof that the authorities want companies to comply with whistleblower requirements.
Thanks. It's very, very serious indeed.
Yeah.
I don't know if Nuala or Catherine would like to explain the Irish point of view on this specific issue.
Yeah, Patrick. So our draft legislation is following the directive on most of the issues that we've discussed today. Certainly, it's creating a lot of potential criminal penalties and fines as well, similar to the other jurisdictions. And as Nuala pointed out, the big change in Ireland will be the requirement for private companies to organise themselves into having internal reporting mechanisms. An interesting topic for discussion is on the anonymous reports that we haven't really touched on yet. So our current legislation proposes not to require anonymous reports to be dealt with unless it's considered appropriate. And again, this is in line with the directive. But that's been getting a bit of criticism, with some commentators saying that is quite regressive. And what we would advise our clients certainly would be to be careful about the fact that there is no mandatory requirement or obligation to follow up on anonymous disclosures, because say, for example, something came out in the public domain and it turns out that it simply wasn't investigated on the basis of it being anonymous, and that could have quite serious repercussions for the organization.
Thank you, Catherine. We still have a couple of minutes to hear 2 or 3 of you guys. I don't know who would like to explain his or her national point of view on this. No one else. So in this case, I would like to go on another question. So we go on another slide. Thank you very much. So this slide is: has your legislation set the minimum, or will set, you understand me obviously, standard imposed by the directive, or has your national legislation gone further or will go further, and how do you explain that? I'd like, maybe because I've not heard from you for a long time now, Marcus, can you tell us the German possible response to this question, please, Marcus?
Yes, Patrick, thank you. Germany, in the current situation, is only transposing the minimum standards. If you ask me why, I would say the main point is that Germany was so late with the code that now they hastily provided some sort of code to have at least something to show. And this is the reason why I think there was no discussion if Germany would like to go further, and therefore now stuck to the minimum standards. But as I said at the beginning, the draft that is in a very early stage is highly disputed. For example, trade unions, they would like to have a higher voice within the whistleblowing code and want to have a decision when it comes to installing whistleblowing channels. So this is now in the discussion, and I don't know how the code will look like when it is finished, if it is finished this year. And maybe why there are minimum standards as well, maybe due to the historical skepticism, the lack of tradition of whistleblowing. But I would say the main point is that Germany was very late and had to provide something. Yeah, that is the German point of view. Thank you.
Thank you, Marcus. Pascal, I also understand that the Netherlands, you are considering transposing the minimum requirements. I was a bit surprised by that, but there is probably a good explanation for the Dutch situation. Please tell us a little bit more, Pascal, about this.
Yes, of course. Well, we already have an existing law that protects whistleblowers. So the idea was, okay, we have this obligation to translate the directive into local legislation. So we will only do the minimum and update our already existing law. But also on points where you have a choice, for example, whether or not you're going to create fines for non-compliance. The decision was made, no, we're not going to implement those either. It's mostly a civil law matter, the protection of whistleblowers, to a large extent, I would say. There is some parliamentary pushback. We're still in a legislative process, and Dutch Parliament said, no, you really have to look at, well, maybe the possibilities that you have under the directive, but also maybe repair the things that are not good about this law, not necessarily related to the directive. So we may see some changes when the legislative proposal will be updated again somewhere before summer. That also includes some matters that are maybe above the minimum requirements of the directive. But we will have to see, because hopefully we will get a law also, well, maybe this summer if we are lucky.
So it's not completely over, if I understand you well, Pascal. As you can see, ladies and gentlemen, most of the countries that are represented today are considering going further than the directive. You have Spain, Sweden, France, Ireland, and Luxembourg. And so maybe I'd like to ask my friends Katrine and Nuala to tell us how the Irish legislation could go further than the directive. Please, ladies.
Sure. Well, kind of similar to Pascal, we have existing legislation in place, as we've discussed. So we currently, the bill is drafted, doesn't go that much further than the directive, actually, other than, as I mentioned, in relation to penalties. So the directive requires member states to provide for effective, proportionate and dissuasive penalties. It doesn't actually say that you have to create criminal penalties, but that's what we're proposing to do. So I guess that's where we're going further. Some of the discretionary provisions have been debated in Ireland, and current approach is that we're not going to go with some of those other discretionary things. So that would be, for example, a reporting mechanism for entities with less than 50 employees. That's not in our draft legislation currently. Another interesting one is in relation to measures of support. So the directive provides that member states may provide for financial assistance, including psychological support for whistleblowers. But again, our bill doesn't currently have that. So yes, as I said, really it's just penalties at the moment. It looks to be where we're going a bit further than the directive.
Thank you very, very much for this. Juan Carlos, even if Spain has only sectoral legislation, I'm happy to understand that the Spanish Parliament intends to go further than the directive, which is of course good for the whistleblowers. Can you tell us how the Spanish Parliament is doing or will go through this way? How will they do that?
Yes, really in Spain, the authorities are very committed with all the corruption cases that we have here in Spain with all the politics, and this is why they are trying to develop and regulate a harder regulation related with whistleblowing channel. In one of the cases, there is in the preliminary draft is included like an independent authority for whistleblower protections. This is something that this is not included in the directive, and the Spanish authorities are considering to create also as a complement of the internal channels of the company, this public authority to control also the procedures. And for me, as I said previously, the most important part is the very serious fines, administrative fines, that they are thinking to include, because we are ranging penalties from 30,000 euros to 1 million euros in case of legal entities, and also for individuals, in order to prevent something that perhaps we are going to discuss in the following panels, that is related with the false claims that perhaps sometimes we have or we receive in the whistleblowing channels, because there is also a fine established for these individuals that they commit a false claim, or that the company can have enough evidences about a false claim, because there is also a fine for 30,000 euros to 300,000 euros. That is really something that could prevent individuals from using in a bad way the whistleblower channel.
Yeah, what is interesting when we hear you, Juan Carlos, is the level of penalties, which are very, very high, I have to say.
Yeah,
and higher than in France at the end of the day. Magdalena, regarding Sweden, my view when we discussed together is that you told me that the new Swedish legislation goes further because it also covers reporting of issues that are of public interest. Can you tell us a little bit more about this? Because public interest was also discussed by Pascal, and it's definitely a real challenge.
Yes, it is definitely a real challenge. And the reason for the government introducing this criteria, it was that we decided to completely replace the previous act. And the directive has very clear provisions saying that the implementation of the directive shall under no circumstances result in a reduction in the level of protection already afforded in the various member states. So it was necessary to include this criteria in the new act. And of course, it will be, I believe, very difficult to assess what falls under issues of public interest. And it has been said that complaints about the employee's personal work situation, that is never considered as an issue of public interest. But if the behavior from the employer is completely unacceptable from a broader community view, for example, if a worker is improperly used as labor, then it could be a matter of public interest. So this assessment is not at all easy to make. And of course, there is a risk that employees and other persons who want to blow a whistle will not do that because it's so unclear to understand if they are covered by the protection or not. Mm. And also talking about sanctions, it's very interesting to hear about the other jurisdictions, because in Sweden, the sanction is damages in case an employer breaches the prohibitions on retaliation and so on. And it would constitute economic loss, that is loss of income due to the behavior by the employer, and also general damages for the breach. And those damages would amount to between 5,000 euro and 10,000 euro. So one can question whether the directive's that requires member states to provide effective, proportionate, and dissuasive penalties is really fulfilled in regard to those damages. We will see.
Okay. Thank you for this. Régis, even if Luxembourg had no legislation, I would not say surprised, but very interested to hear from you that the future Luxembourg legislation on whistleblowers should go further than the directive. Please tell us more about this, Régis.
Yes, exactly, Patrick. Luxembourg legislation and the current Bill of Law goes further than the directive regarding the material scope, which is much larger than the one provided for by the directive. In fact, its violation is any act or omission that is either illegal or contrary to the object or purpose of the national law or European directly applicable law, if the consequence is a disturbance of public interest. So it's more or less everything except the 4 specific matters which have been provided for and which are defined in Article 3 of the directive, which are national, any document are not protected, it's documented information relating to national security, covered by medical secrecy, covered by professional secrecy, and also the last one, the rule of criminal proceeding. On that point, there is one interesting question I just wanted to share with you on that point. It's, of course, broad, but an interesting question is that the Bill of Law refers to national law. So, of course, it refers to Luxembourg law, but the question is, does it also refer to breach on another national law? And the question is, if you take the Luxembourg international context, the question is not purely theoretical. So let's imagine, for example, the employee of a Luxembourg company, which is an affiliate of a German group, for example. And at the occasion of the performance of his work, the employee learns that the German company breached German law on protection of consumer. What if he report, will he be protected if he or she reports to the Luxembourg employer through the internet channel, or as the case may be to the Luxembourg authority through the external channel? So that's an interesting question, and Luxembourg Bill of Law is maybe too large on that point, and it may be clarified. Otherwise, I suspect that sooner or later the Luxembourg court will have to deal with that question.
Okay, Régis, thank you for explaining the Luxembourg point of view. Paola, I know that Italy has not yet any legislation and it's still in progress, but nevertheless, what do you expect from the Italian Parliament? Do you think that the Italian Parliament will just stick to the directive, or will go further? What are your thoughts about this, Paola?
Okay. Well, in Italy, it's usually very difficult to make provisions about the Parliament work in progress, because we get surprised very, very often. What can I say is that the contents of the regulation in that moment applied in your legal framework is the contents are really compliant. Already compliant to the directive, I think, but the main lack is what is the topic I underlined at the beginning of this discussion. In particular, the context, the placement, the connection of the whistleblowing regulation on the decree regulating the companies' criminal liability of companies and legal entity, and it's not mandatory framework, because this is the main problem for real enforcement of a general enforcement of whistleblowing in Italy, is that it's not mandatory at the moment, this regulation. So I think that the contents of the regulation are compliant to the directive, but the substantial application, which is not general but just limited to the liability of the criminal liability of the company, is that something that make less strong the application of whistleblowing regulation in Italy. So I expected that the Parliament will change this perspective.
Okay. That's also.
Just
please, Valentina, please go ahead.
Just to say that the delegation law to the government already provides that the government, in issuing the new legislation decree, will be free to grant more favorable measures in favor of whistleblowers and provide for more favorable rules within this context, or in any case to keep the current regulation, which, as Paola said, is already granting a very good package of protections within the whistleblowing systems. Mm-hmm. Thank you.
Okay, thank you, Paola. Thank you, Valentina. Since we have 3 minutes ahead, just to give you the French point of view, the French. How do you say that, Magdalena? Ombudsman, the French defender of rights in France, said at the end of the year 2019, they urged officials to pass a new law that would be stronger than the directive. And they said that the government should not just accept a strict transposition of the directive. I will probably say that the agency has been heard on some points. Just to give you a couple of examples, let's take the issue of anonymity of whistleblowers. As you know, the EU directive gives a certain discretion to member states to decide whether or not, let's say, business organizations should accept anonymous report. France, when in the new legislation, France said that anonymous whistleblowing is expressly authorized. That is one point. The second point I'd like to say, and I explained already this view, which in my view is very important, the concept of facilitators. Whether we like it or not, a whistleblower remains in the directive and in the national legislation an individual. And not a non-governmental organization, not a trade union. And so the concept of facilitator is interesting, because this concept, you can take advantage of this concept in order to go further than the directive, which is the French point of view. A facilitator can be a trade union. It can be an association. Every organization assisting whistleblowers in their work, in preparing their report, they will be protected against retaliation. So at the end of the day, my view, and I'd like to make sure that you all agree with me, and if you disagree, remain silent. No, not at all. Please say. But my view is to say, even if from a cultural point of view, our respective countries we're not very fond of whistleblowing and all this stuff because we don't have, at the end of the day, this culture, which is true. I have seen many countries really prepared to go further. Luxembourg is a great, I think, example. And so definitely there is a real interest in protecting whistleblowers, and probably it's not just a question of Mediator, Facebook, LuxLeaks, and all these scandals. It also goes further with discrimination issues in the workplace. And we, the employment lawyers, and you, the HR director, the legal director, you will have a role to play. So this is my view. I don't know if any of my friends, panelists, wants to add something. If not, as you can see, dear Florencia, group 4 is a great group because it's 4:15 and we are on time. I hope you will be as well, Florencia and the rest. So, ladies and gentlemen, thank you so much for being with us today.